Okay, well, thank you everyone. Good morning. Thank you for joining us today. My name is Jay Huang. I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the H-1B visa, which allows individuals to work for a U.S. employer in a specialty occupation. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we are here to help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive guide for the visa type that we'll be discussing today, which is a booklet of information that you can use as a reference. We will also send you a link where you can sign up for additional webinars that are coming up in the future, and also this webinar as it will be recorded. We will also make this webinar available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button as we do regularly upload a variety of immigration law related videos that can be very helpful to you. We will also send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. So today we're very lucky to have Kelly Wiener, who is a partner at Scott Legal with a wealth of experience in the H-1B visa, who will be presenting about the requirements and the procedures of applying for an H-1B visa and the main considerations. And I'll also be one of your panelists. Finally, for any questions you may have, please feel free to add them in the chat box or use the Q&A function, and we will try and get to all questions. So without further ado, let us start the presentation, and I will start by going over some of the basic information about H-1B visa eligibility and the lottery process. Okay, so let's start by talking generally about what are the H-1B requirements. So generally speaking, the H-1B visa is a work visa that allows a foreign national to come to the United States to work for a specialty occupation for a U.S. employer. Specialty occupation is a technical term, and we will explain in a little bit more detail later. But generally, it means a job that involves the theoretical and practical application of a specialized area of knowledge, which would normally require a bachelor's degree or higher in that specialty to do this work. And examples would include architecture, engineering, accounting, graphic design, and many others. So to be eligible, the foreign worker must have at least one of the following credentials: a U.S. bachelor's degree or higher required to practice that specialty occupation. So if that occupation is a lawyer, for example, a law degree would be required. The foreign worker could also qualify with a foreign degree if the person can obtain a U.S. education equivalency report that confirms that the foreign degree is equivalent to the U.S. bachelor's degree or higher in the specialty. You can also qualify with an unrestricted state license, registration, or certification that authorizes the person to fully practice the specialty occupation. Or in the alternative, the person may also be able to meet eligibility with equivalent work experience. For those without a traditional four-year bachelor's degree, there is a 3-to-1 rule that applies. So 3 years of specialized work experience in the specialty is equivalent to 1 year of formal education in that specialty. So for example, 12 years of specialized work experience can be considered the equivalent of a bachelor's degree in the specialty. The other requirement is that the H-1B worker must have a job offer from a U.S. employer. And another thing to add on to this is that the salary offered must meet the prevailing wage requirement, which is that it must equal or exceed the average that a U.S. worker is paid in that level of position in that particular region where the job will take place. Right, so let's talk a little bit more about the position, which must be a specialty occupation. So you can't qualify for an H-1B visa with any type of job. It must be a job that is a specialty occupation. So you must meet at least one of the below. So the bachelor's degree or higher should be normally the minimum requirement to work in that particular occupation. For example, if you're an accountant and if it is normal to require a bachelor's degree in accounting or related field to do that job. Normally does not mean always, but which is usual, typical, common, or routine. You can also show that the bachelor's degree requirement is common to the industry in parallel positions among similar organizations, or in the alternative, the employer may show that this particular position is so complex or unique that it can only be performed by an individual with that level of degree. You can also show that the employer itself normally requires a degree or equivalent for that position. Finally, you can also prove that the nature of the specific duties to be performed is so specialized and complex that the knowledge required to perform the duties is usually associated with the attainment of a baccalaureate or higher degree in that specialty. All right. So let's talk a little bit more about the logistics of what it takes to apply for an H-1B visa. Now, an important thing to note with regards to the H-1B is that a cap exists in the number of new H-1B petitions that can be adjudicated every year, which is 85,000 total. And to get a new H-1B visa, you need to apply and be selected in the H-1B lottery that is held every year in March in advance of the following fiscal year, which begins in October 1. This means you would enter the lottery in March, but the start date of your job can't be earlier than October of that year. So the regular cap petitions, this is referring to bachelor's degree holders. And the number for that is 65,000 petitions. And there is also a separate cap, 20,000 cap that is reserved for those who have a U.S. master's degree or higher. And to qualify for this master's cap, it needs to be a U.S. degree to qualify. Now, if you already were approved for this, if you were already selected in the lottery before, and if you already have an H-1B status and you are trying to do a change of employer or an extension petition, then you are not subject to the H-1B cap and you can file this petition at any time. So because every year many times more than 85,000 registrations are submitted every year, USCIS runs a lottery to select the eligible petitions that can move forward. And actually last year the number was a little lower. It's 336,000 registration that came in, so you can think about a chance that is a little bit over 25% of selection. But still, it is quite a low, chance of selection. Now, one thing to note here, very important, is that this year, 2026, the DHS has announced that they will be now using a new weighted lottery system, which means this will no longer be purely random selection. And we will go a little bit more detail on what is changing with the 2026 lottery system. But basically, in this new system, applicants who are offered higher wages will have a better chance of being selected than applicants who are offered lower wages. And we'll explain a little bit more about what's changing in some of the following slides. All right, so let's talk a little bit more about the H-1B lottery in general terms. So what USCIS uses is a computer-generated random selection process to select the petitions. And there are some types of employers that are exempt from this cap. And for those types of petitions, the employer can sponsor an H-1B employee at any time. So those cap exempt employers include universities, a university affiliated nonprofit entity, such as a teaching hospital affiliated with the university medical school, for example, a nonprofit research organization, or a governmental research organization. So if your employer qualifies as in these categories, then you don't need to worry about the random selection and the cap schedule. All right, so let's get into a little bit more detail about the H-1B application process. So as I mentioned, for most new applicants, they would need to register for the lottery first. And the next lottery is in March 2026 for job offers with a start date on or after October 1st, 2026. So in March, what will happen is USCIS will open a 2-week registration period where people can submit a registration for the lottery. Then the USCIS will run the lottery and announce the results of selection by March 31st, 2026. And if you're selected, you will need to file the H-1B petition within 90 days of selection, so before June 30. That was the case last year. So now the registration for the lottery is done online. So the H-1B employer will need to make a USCIS online account, and the employer or attorney can submit the H-1B registration. This year, it will require a little bit more information than before. And we will talk a little bit more about the changes that are upcoming, but it will not be a purely random lottery, but a weighted lottery based on the proffered wage. As such, the offered wage and the type of job will need to be disclosed upfront, and it will be difficult to change this later. So let's say if you're selected, then what needs to happen? So you will need to file, the employer will need to file a labor condition application with the Department of Labor, which will return a certified version. Then the employer will go ahead and file the H-1B petition. Now, the H-1B petition can be filed either as a change of status if you're currently in the United States in another status and if you will be maintaining that status, or consular processing if you are abroad and need a new H-1B visa. However, as you all would know, in September 2025, President Trump announced a proclamation imposing a new $100,000 fee for new H-1B visa applications that are processed abroad, as a consular processing case for new H-1B petitions that are filed. So at this time, change of status petitions that are processed from within the US are exempt from this fee. However, applicants who need to be applying for a new H-1B visa based on a new H-1B petition filed after the effective date will be subject to this fee. Okay, so now let's look at a table that compares what will be changing with the 2026 lottery. And compare this with what system has there been in the past. So let's start with the selection method. The current lottery system, which is in place before 2026, is a pure random selection. So everyone who applies for the lottery would have one entry into the lottery. Now, there is still the advanced degree lottery, which is in the bottom of the table, which is still there. So if you have a U.S. advanced degree, you will have naturally a higher chance of selection because there is that separate cap. But other than that, within each pool, it is one entry per person, so it is pure random selection. Now, with the new lottery system in 2026, it will be a random selection, but with wage level based weighting. And what this means is it will not be one entry per, per registration, but entries that have higher offered wages may get multiple entries. So if the offered wage, places the registration on wage level 2, for example, you would get 2 entries into the lottery instead of 1 entry. If it is a wage level 3 offer, then you will get 3 entries. And for beneficiaries who are offered wages that correspond to wage level 4, the person will get 4 entries into the lottery. However, it is still true that it is a beneficiary-centric system, such that there is only one unique registration per beneficiary for the registration. And if there are multiple registrations with different wage levels in this new system, USCIS will use the lowest wage level registration if there are multiple submissions. But the rule is that, per beneficiary, there is one registration that will happen, and those registrations will be multiplied based on the table, based on the wage level. So, consideration of wage level, the SOC code of position, and area of intended employment. All of these were not a factor in the existing lottery system. However, with the new lottery system, the odds of selection will differ based on those elements. Because the wage level, SOC code of position, and area of employment, they all are factors in determining which wage level will be assigned to your particular registration. And if you are assigned a higher wage level for that particular job offer, you would get multiple entries as opposed to just getting one entry. As I mentioned before, the advanced degree lottery is still in place, and the wage level based weighting would also apply in the advanced degree section of the lottery as well. So let's talk a little bit about the expected advantage or disadvantage in place based on the wage level. So under the existing system, the amount of the offered wage did not have any impact on the likelihood of selection in the lottery. However, with this new system that's coming in 2026, applicants who are offered a level one wage will see about a 48% decrease in the selection chances. Level two wage beneficiaries would see a slight increase in the selection chances. And level three and level four wage offered applicants will see pretty much of a significant increase in the selection chances. And this is based on the historic projection of how much volume each level saw in historic volume distribution data from USCIS. So because so many more level one registrations are in place, the difference is actually not that great, but there is definitely will be an increase in selection chances for the beneficiaries who have level three or level four wage levels, especially. All right, so now let's go over some of the strategic considerations that we recommend thinking about for the 2026 lottery. So key considerations for employers and beneficiaries. The wage strategy will directly now affect odds of selection in the lottery. So positions with entry-level wages will remain eligible, as we went over in the table, but they will face a lesser chance of selection. Employers may choose to offer higher wages to the foreign worker to increase chances of selection, and that can be one strategy for increasing the chances of selection. Now, the other thing to consider is that registration will require reporting of the offered wage, the SOC code of the position, and the area of intended employment, based on which the registration will be weighted, right? So setting these details accurately at the time of registration will be critical because discrepancies in those details between the registration and the H-1B petition can lead to denial. Okay, so now I will hand it over to Kelly and she will continue the presentation.
Thank you, GA. All right, we're going to switch gears a little bit to talk about family considerations for the H-1B. So, big question, can the H-1B employee's family come to the US? And the answer is yes. Your spouse and any unmarried children who are under 21 can come to you on an H-4 visa. Children and your spouse can study in the US. Normally, the spouse cannot work. However, there are some exceptions. So, if the H-1B visa holder is at a certain stage of the green card process, either the beneficiary of an approved I-140 or have been granted H-1B status under certain sections, of AC-21, which permits them to extend their status beyond the normal 6-year limit. So in those cases, the spouse can apply for a work authorization card to be able to work in the United States. All right. So another common question, who can pay for the legal and government filing fees? And there are some rules here. So, when it comes to the attorney's fees, generally the employer cannot require that the employee pay for or reimburse for attorney's fees associated with an H-1B visa. And also side agreements to kind of, pay the fee back are not permitted. The employer also cannot take the fees out of the employee's paycheck although there is some very limited exceptions, kind of if deducting the fees wouldn't reduce the employee's pay below the required prevailing wage. One exception is that the H-1B employee can pay the legal fees for their dependents or for their spouse and children. For government filing fees, the employer must pay for these, except that the employee can pay the premium processing fee. There are, extensive fees, a fee for the I-129, an anti-fraud fee, the Competitive Workforce Act fee, and then, as GA mentioned earlier in the presentation, there is a new fee that applies, to certain petitions that are, filed for consular processing or consular notification. So it is important to understand whether you're subject to that fee, of course, before filing the petition. All right, what happens if you lose your H-1B job? The first thing you want to do if you do lose your job when you're on an H-1B is check your I-94. So the I-94 will either be available on the government website, if you kind of most recently entered with an H-1B visa, or if you did a change or extension of status in the United States, your most recent I-94 may be on the bottom of that original approval notice, the I-797A. And you want to immediately check that because if there's, let's say you're fired and there's a year left in your H-1B employment, you would get a full 60-day grace period. During this time, you can either make plans to depart the US, look for a new job and have a new employer file a change of employer H-1B petition, or change to a different visa status. It is important to note that this is a discretionary grace period, so the government does have the ability to shorten it, at their discretion. Uh, Additionally, this has happened on a very, very small scale, but it is important to know there's a potential slight risk that once you're fired from your H-1B job, your employer is required to notify the government within 30 days that you are no longer working for them on that I-129 petition. It's been very sporadic and not consistent, but there are some people who have reported getting, notices to appear in immigration court, based on no longer having employment in the United States. Again, this is not something that we're seeing kind of across the board and is an extreme departure from kind of prior practice, but something to keep in mind. So if you are very, very risk averse, you may want to consider either having a new petition filed within the 30-day period, or departing the US within that time frame, just to avoid that. All right, so talking a little bit more about the grace periods, there's kind of two grace periods applicable to H-1Bs. The first one is that 60-day grace period that I talked about. As mentioned, this is available for 60 days if your I-94 is valid for 60 days or longer. So if let's say that you are fired and you only have 30 days left on your I-94, your grace period is 30 days. It's not 60 days. You also cannot work during your grace period, but it is kind of meant to be there to provide an ability to kind of make plans to, depart, change status, uh, or change to a new H-1B role. There's also this 10-day grace period, and sometimes having these two grace periods confuses people. The 10-day grace period is not really relevant, if you lose your job. The 10-day grace period is more relevant where if you are approved for an H-1B, the approval can be granted for up to 10 days prior to your employment starting to kind of give you the ability to enter the US and get a bit situated before your employment officially starts. And then they will also often grant a 10-day grace period at the end of the H-1B employment period. You cannot work during this point in time, but it is meant to kind of give you the ability to, leave the United States or, stay in status, change your status, before making plans to depart. All right, how many times can you renew your H-1B visa? So the H-1B, you can initially be granted for increments of 3 years, or under the new rule for certain applicants, initial increment of 18 months. And then you can renew up to 6 years total. Only time in the US counts towards the 6 years. So let's say that every year you spend 2 months out of the country, or a month out of the country, or even a couple weeks. Um, you can file towards the end of your 6 years what we call a recapture petition. And as long as you've kept records of your travel history, your I-94 travel history, perhaps, flight receipts, passport stamps, you can demonstrate that you spent that time outside the United States. You can recapture that time to work for longer in the United States. There's also a couple exceptions that allow you to extend your H-1B status beyond 6 years. So they're described here. One is called the lengthy adjudication delay exemption. And this means that you can, both of these are related to people who are in the green card process. And it's meant to kind of smooth the way for people who are in the green card process, but coming up to the end of their H-1B time. So if 365 days have passed since you filed your PERM, your labor certification with the Department of Labor, or if the I-140 petition was filed 365 days ago, you can, get a 1 year extension, up until, if the I-140 is denied or the labor certification is, denied or revoked, at that point you can no longer rely on them, for those extensions. The second, exemption is the per country limit exemption. And this allows, let's say that you have an approved I-140, but you can't proceed with your green card case because your priority date is not current. So there's many people who are kind of, in this backlog, particularly people born in India or China. But really EB2 and EB3 are backlogged worldwide at this point. And so if you're in that situation, you can potentially extend your status for, in 3 year increments, by demonstrating that, you have an approved I-140 and, showing the current visa bulletin, showing that your priority date is not current and you're not able to, proceed with the green card process at this time. All right. Do I need an H-1B to apply for a green card? Sometimes there's this perception people have that you need to get a certain type of temporary visa before you can apply for a green card, or a perception that getting a certain type of temporary visa means you automatically will get a green card at a certain point. And neither of these things are true. So one, if you are outside the United States and eligible for a certain green card category and can either apply for yourself or have a petitioner to apply for you, they can do that, directly. Secondly, having a temporary visa for some length of time does not ever automatically lead to a green card. However, it's very common for people on an H-1B if they, sometimes their employers want to keep them here permanently, and then they will transition to a green card, based on that employer wanting to keep them here. So sometimes that's how these perceptions, come into play. So you do not need to be on an H-1B visa to apply for a green card. You can be on another visa. Let's say you're on an O, you're on an E2, you're on a TN. However, there are very specific benefits that you get as an H-1B visa holder that you may not get on some of these other visas. So the H-1B visa specifically says you are allowed to be here temporarily, but also have this intent to immigrate permanently to the US. And this is called dual intent. There's many other visas that do not allow for dual intent. So for example, an F1 student visa or a TN, visa. For these, you have to show that you have the intent to depart the United States, once the visa status ends. So the H-1B, there's benefits to being on it when you're on the green card process because you don't have to worry about these conflicting, levels of intent. Also, you can, in certain circumstances, as long as your H-1B employment is continuing, you have a valid H-1B visa stamp on your passport, while the green card application is pending. If you're doing an adjustment of status in the US, you can still travel freely on that H-1B visa. And this is a really large benefit that a lot of other people don't have. So if you're on an F1, if you're on a TN, and your intent has changed and you file an adjustment of status, you cannot travel on that visa anymore. You have to stay in the United States until your green card application is approved, or you have to apply for travel authorization and only travel based on that. However, the travel authorization applications themselves can take several months. So for lots of people, once they file the adjustment of status, they're kind of stuck in the United States for a period of months or even longer before, they can travel. So to be able to travel freely during the green card process, something H-1B visa holders can do, it's a big benefit that they get. The other benefit to the H-1B is that there is a process for extending the H-1B status while you wait for your immigrant visa to become available. So let's say you're on an L visa, which the L visa has some of the same benefits that the H-1B does. It's a dual intent visa. You can travel, in certain circumstances when the adjustment of status is pending. But once you run out of your time on your L1, you max out the 5 years or the 7 years, you don't have any ability to kind of maintain that underlying status. So the H-1B does give you that ability, which can be something that's definitely favorable because, if you're here on H-1B status, you've maintained your underlying status. Let's say there's some issue with your green card and it gets denied for some reason. If you did not have any underlying status, you really need to leave right away. You don't have any status. If you are on your H-1B, it gives you a little bit more time to kind of plan and figure out your next steps. Okay, so what is the green card process after an H-1B? So the normal, process that most people will follow is applying for an EB-2 or an EB-3, and this is an employer-sponsored green card. This usually happens through the PERM process. There's another process under the EB-2 called the National Interest Waiver. We're not going to get into that here today, but it's beneficial because it can be sponsored by a company or it can be self-petitioned. If you're interested in it, we do have separate webinars that are fully devoted to the National Interest Waiver. But today we'll primarily just talk about the perm. So while you're on an H-1B, your employer can choose to sponsor you for a green card. This involves the employer filing for a prevailing wage with the government, testing the labor market to determine if there's any willing, qualified, and available U.S. workers who can do the job. If they do not find any during the labor market test, then the employer can file a labor certification with the Department of Labor. Once this is approved, the employer can file an I-140. That's a petition that says we want to sponsor this person for a green card. And they have to file that with proof that they have the ability to pay the required wage and also proof that the employee meets all the requirements for the job that were outlined in the labor market test. Um, at that point, if the I-140 is approved, or the green card category is current, or the priority date is current, then the employee can also apply for a green card, either through the adjustment of status process with USCIS, where you're staying inside the U.S., or from outside the U.S., where your approval for the I-140 would go to the National Visa Center. They'll collect your documents, and once they have everything, they will send it to the consulate in the country, of your nationality or where you most recently lived prior to moving to the U.S., and you'll get your green card through the consulate, which is called a consular process. All right. So, do you have to prove that the company cannot find U.S. workers for the H-1B? So, this is not a requirement for the H-1B for the majority of employers. Sometimes people get confused about this. One, because so many H-1B visa holders are also in the PERM process where you do have to test the labor market. As well, there are certain H-1B employers, so H-1B dependent, meaning there's a certain percentage. Of H-1B workers, a very high percentage at a company, or willful violators, so people who've been found to, not be in compliance with the H-1B program. For them, they have additional attestation requirements where they have to attest that the job, that the H-1B is, worker is not going to displace U.S. workers. They have to take those steps to recruit. But that is not the norm. That is a very small, percentage of kind of H-1B employers. And the normal H-1B employer who's maybe sponsoring, just a few, H-1B workers, where it's not a high percentage of their total workforce, is not going to be subject to those requirements. So again, this is, this testing the labor market. This is a requirement for the PERM process, and for H-1B dependent employers and willful violators, but not for, the majority of majority of employers applying for H-1B workers. All right, so we've reached the end of the presentation, and we can see if any questions came in.
Yeah, just one question from an attendee. If I travel to my home country for stamping of H-1B, does my employer need to pay the $100,000 fee for me to enter America? Um, yeah. So if it's a brand new petition, right? That's filed after the date. But if you process it as a change of status, though, I think you're still exempt for the stamping
Correct.
itself. Yeah, but
Yeah, correct. So
yeah.
there's like the way that the guidance is out right now is they have kind of information they've provided. It is a bit of a chaotic mess, because the guidance, in this kind of policy and the way it was implemented is a bit outside the norm of how regulatory changes are usually made. That being said, they have put guidance on the USCIS website that says if you get an approval for a change of employer, a change of or extension of status or amendment in the United States, and then after that, you travel for your visa stamping, you will not be subject to the fee. However, if you file your H-1B, for example, for a change of status, and they approve the H-1B for consular notification, but they deny the change of status for some reason, like you've not maintained your status, then you will be subject to the fee. So it is important to, discuss with your employer, with your with the company, also understanding kind of what is the current state of visa stamping, right? Because consulates, now there's kind of additional hurdles with kind of checking social media and things like that. So, and, kind of limited availability of appointments. So you do want to make sure before you leave, the best case scenario would be that you kind of both check with your employer, secure the appointment, and make sure that kind of you've already changed your status into H-1B status, before you attempt the visa stamping.
Yeah. Okay, so it looks like we don't have any other questions that came in. So I just want to, yeah, take this time to thank everyone for joining us today. Thank you, Kelly, for sharing your expertise. And yeah, I hope everyone has a good day. And if you'd like to discuss your particular case further, please feel free to set up a consultation with us. Thank you.
Thank you.